Good morning, everybody.
Morning, Rabbi, gentlemen, and young man.
Morning, Rabbi.
So, yesterday we saw a halacha that was a little bit in the gray area, and that is we know that based on what the Shulchan Aruch writes, you can prevent damage from coming onto your property before it comes onto your property. But what you're not allowed to do is once the damage has come onto your property, let's say a flood, you cannot pump the water out so that it goes onto your neighbor's property. But there's a middle ground between those two categories, and that is what would be the din if the damage is already on your property and you just want to prevent it from coming further onto your property. So you want to create a barricade on your property itself after it's already on your property. Are you allowed to do that? So that's what we were discussing. That was the last thing we discussed yesterday. So the Imrei Yaakov says that it seems to him that that's okay, even if you're creating a diversion or a barricade on your property itself to prevent it from coming further onto your property, then you're allowed to do that. And he gave us a reference to a sefer called Choshen, which is also a contemporary sefer, was written by Rav Bloy, probably within the last 40 years. It has a lot of it's a very extensive sefer with a huge amount of, I think it's there up to a dozen volumes in all of the laws of Choshen Mishpat. But we'll take a look at it. Let's take a look at the sefer, and we'll try to get some clarity. He writes, and this is his volume in the laws of Nezikin, the laws of damage. Even though you're not allowed to save yourself from damage by using your friend's property to allow your friend's property to get damaged instead, but nonetheless, Imrei nezek omed lavo alav. But if you see damage is imminent to come upon you, yachol lemonao ulahatzil atzmo, you're allowed to prevent it from the damage of striking you. Even though that through you preventing the damage from coming to your property, it'll be diverted to your neighbor instead. Okay, and that's a direct quote from the Shulchan Aruch. But then he says, "V'lochein," and therefore, haroe amas hamayim ba'al lishtot sadehu. If you see that there's a flash flood that's coming to wipe out your field, ad shelo nichnas l'sos sadehu. So then, before the flash flood comes onto your property, yachol ligdor shelo tikanes, you can put up sandbags or whatever it is to prevent the flood from coming onto your property. Afal pi shal yidei zeh tishtov sadeh chavero, even though that through that action, the water will divert onto your friend's property. And of course, like the way we had explained it, is that your friend can also create his own barricade and prevent the water from coming onto his property. But just because he chooses not to, doesn't mean that you should just allow the damage to befall you. Aval, mishenichnas alisadehu, asr lahutzia im al yidei kach yigrom nezek la'acher. But once it's on your property, you're not allowed to remove it if removing it will cause it to be dumped on your neighbor's property and cause him damage. And so here we take a look, and this is a direct quote from the Nimukei Yosef, one of the medieval commentaries on the Gemara, B'Shem HaYerushalmi, and who was quoting the Talmud Yerushalmi. V'lichora ein bedugma zu kidei lelamed al haklal shel harama. He says, in this example, we're not exactly discussing the rule of the Rama in the Shulchan Aruch. Shaharei midivra Nimukei Yosef nira shebitzad haheter eno osa ma'isa lahavi hanesek l'stei chavero. He says, when you're permitted to barricade your property, and as a result, it diverts to to your neighbor, you're not doing it an active damage to your neighbor. It's just that by blocking the water from coming on your property, it's a byproduct, right? That it's a grumma that you're doing to cause the water to flow onto your neighbor. Elagoder bishalo v'al kain nigram shahamayim yispashtu l'stei chaver, as I just explained. Masha'ein kain kisha'amas hamayim kvar nichnaso l'sadeh ubala hotzia. But when the water is already on your property and you want to pump it out, osa ma'isa nezek shemechavein hamayim l'sadeh chavero. So there it would clearly be usher to pump it out so that it goes onto your neighbor's property. And so therefore, you're not really addressing whether this is before the damage or after the damage, but rather the major criterion is it passive damage or active damage? Okay, that's the main criterion. Ela imkain yachol limnoa hanezek beli maisa muter uva maisa aser. So that's really what he points out. He says, really, the main issue is not pre-damage or post-damage, but rather, are you passively preventing, causing your neighbor's field to be damaged, or are you actively causing your neighbor's field to be damaged? And therefore, it would stand to reason that if the distinction is not before or after, but rather active versus passive, then even if the water has already come onto your property and you wish to prevent it further from damaging your property, you should be allowed to barricade it, even though that's going to passively cause damage to your friend. So this is the point that the Imrei Yaakov has made, but he's really expanding on it. And he's saying, and therefore it's altogether possible that for preventing any further water from coming onto your property, even though it's already on your property, but you want to prevent it from, let's say, going further into your property, that would also be legitimate for you to block it, provided that you're not actively spilling it onto your neighbor. The problem, the only difficulty is that we don't see this explicitly in any of the authorities. In other words, none of the authorities address that gray area of where the water is already on your property and it's already, let's say, flooded half of your field, and you just want to prevent it from flooding the other half. So you want to put the sandbags up on your property itself and have the diversion created so that it'll go somewhere else, and that somewhere else happens to be your neighbor. So it stands to reason, just like the Imrei Yaakov and now Rav Blau and Pischei Choshen say, that it should be okay. Well, mikol makom, but regardless of that, nira she'im nichnasim mayim mistei chavero b'peshia mitzad chavero. Let's say, here's another scenario where you would certainly be allowed to even do something active. Let's say there is water that is flowing from your friend's field because of his own negligence. Water is flowing from his field onto your field. That you can certainly prevent the water from coming onto your field, even though that will invariably cause your friend's field damage. In other words, let's say he's created a diversionary system whereby water diverts from his field and spills onto your field. So there, for sure, you'd be allowed to create a barricade, on your property to prevent it, or in front of your property to prevent it from happening, that the water spills onto your property, even if this will directly cause damage to your friend's field, because he created a water diversion system that will save his crops, but at your expense. So you can plug that all up, right? Even if it's going to result in his field being damaged. Avi kematzil atzmo b'momon hamaziko ki hahi deshor sha'ola. And that's what we call saving your property using the property of the damager. In other words, you're not allowed to save your property by using an innocent party's property. But if you want to save yourself from injury with the property of the injurer, then that's completely okay. And so therefore, let's say we're not on a farm, but let's say we're city slickers and bitzinor biyub shel chavero shenistam. So you've got a neighbor, and his eaves trough has, I think that's what the biyub is, if I'm not mistaken. His gutter pipe, I think, is usually how they translate it. Let me just double check.
Biyuf is sewers.
Sewer, the sewer pipe.
Yeah.
Thank you. Okay, so it's his sewer pipe. Shenistam, it gets plugged up. V'hamayim shel hashachen ha'elyon nichnasim leveito. And so because it got plugged, so the water from the neighbor that lives above you is flowing into your house. I guess maybe the plumbing got backed up and his plumbing is coming into your house. Shemutar lo listom hatzinor. What you're allowed to do is that you're allowed to seal off his pipes. Afal pi shebazeh lo yichal ha'elyon liyishtamesh b'tzinor. Even though as a result, your friend will not be allowed to use his pipes anymore. And Ein Lakaman Perek Yud Gimel, and I refer you to the next chapter. Okay, so
there you're just kind of mitigating damage.
You're mitigating damage, even though you're preventing your neighbor from being able to use his plumbing.
Right.
But you're allowed to do that because it's his plumbing that's causing you the damage. Okay. So, I guess, what David and I were dealing with yesterday, we're discussing yesterday. You've got a fellow whose eaves trough is flowing onto his neighbor's property, creating a sheet of ice. So the neighbor would be the damager. So it should be permissible for the other neighbor to unilaterally plug up the eaves trough spout in order to prevent his property from getting damaged, even though that will invariably, if that eaves trough does not cause the water to flow off from his roof, that could cause damage to his roof and ultimately to his property.
Rabbi, I presume he'd have to do it from his property. He couldn't go onto the other person's property and plug up the eaves trough.
I'm not sure. It sounds like that if a guy is damaging you, then you could even go onto his own property and plug it up. It seems
not trespassing.
In this case, there's an easement because it's a zero lot line scenario. So whenever you have a zero lot line where one side of the house sits on the property line, there's an easement to allow for serviceability. That's a common area between the two houses.
Okay, that makes sense.
Right now, but what I'm arguing is that even if there wasn't that legal easement and you are trespassing, aren't you allowed to trespass on someone's property if something from their property is coming onto your property and causing damage? And it would seem that you can go on and trespass on their property to stop that thing coming onto your property and causing damage.
Assuming you've made reasonable efforts with the neighbor to mitigate the problem, otherwise you're trespassing and you could be sued.
Right. Okay, so you're talking about secular law now. So I'm just saying, so you're right. Obviously, you would have to communicate with the neighbor and say, hey, this is causing me damage. What would happen if the neighbor, let's say, is away for the whole winter and you can't reach them, and the damage is coming from his house and is damaging your property? So it could be that you would be allowed to do that. I don't know what the secular law would say about that, but there's got to be some provision that if the neighbor is not around, and he's got a vacant house that's and it's causing damage to my house, there's got to be some provision that would allow me to trespass to stop the damage. I would imagine. What do you say, David?
That would definitely make sense. I mean, if we're going back 100 years, then you gotta get like maybe a based-in order to allow you. You need to have some kind of documentation, perhaps, that gives you the okay. I mean, under secular law, I mean, obviously you want to speak to a municipal lawyer that deals with issues of this sort,
Right.
and then get proper direction.
Right. But it certainly seems from what Rav Blau has said that according to halacha, you would certainly be in your rights to do that.
Yeah.
I presume we're expecting that you can't stop the damage from your property. In other words, you can't put up some barricade along your property line to stop the water from flowing. Because to me, that would seem more ideal.
Right. But he's talking about, in this illustration, he's talking about where the neighbor above you is his plumbing is blocked up, and it's causing sewer water to back up into your sinks. Right.
Right.
So you would have a right in that case to create some kind of blockage between your pipes and his pipes, even though that'll cause, or just to turn off the just to turn off the water from his
main.
Yeah. The main. Yeah.
I was just thinking in the case that you and David are speaking about, if they could put a barrier at the property line as opposed to going onto the other person's property to stop the ice from forming, that would be better.
Well, it depends. It depends how how much more expensive or how much more labor it's going to be to do Plan B instead of Plan A. If I can go right to the source and plug up the eaves trough, that might be a much more convenient way of doing it than to set up sandbags along the whole periphery of my house.
So I'm not clear from the beginning of what we talked about today why it's a problem that the eaves troughs are flowing onto your neighbor, because I thought we said that if the damage isn't present, but it will happen from the rain, then that's not a halachic problem, because you're not getting rid of water that's already there. It's just the way that it's set up, that's the way it will flow. Isn't that what we said, or am I missing something?
No, we said that the damage has to be imminent, but if it's just going to happen over the course of potentially happen over the course of a very long time, so then it's not you don't have a right to divert it, I think we had said. Let's see. Where was that? I think we'll see more examples of that, where it has to be clear and present danger, clear and present injury. But this is clear and present injury. He's causing water to come onto your property. The neighbor's saying, on a winter day, when I walk outside, there's a sheet of ice. I don't want to slip and break something. He's saying that is a clear and present danger.
Right. Okay.
All right. All right. So there's an interesting. All right. Let me just switch back. Okay. So let me just see if I missed anything here. Okay. So in the Likutim over here, he says, Sheyavo al chavero, that you're not allowed to, what was the language over here? You're not allowed to remove damage from yourself if by removing damage from yourself, you're going to cause damage to befall somebody else. So hamazik biyado o bishar gufo o shezarak even o sheyara chetz behizikbo. If a person causes damage with his own body, right, through his arm or through other part of his body, or he throws a rock or he shoots an arrow and he causes damage thereby, o shepasach mayim al chavero, o al kalim v'hizik, or let's say he opened the spout and that caused his friend to become, or his property to become damaged, O sherok, or if he spit, and that spit causes damage. Areze kemazik biyado, vehim toldot shel ha'adam. All of these things are not indirect, they are direct damage. And you can be held liable in a court. Because even though they're no longer connected to your body, the arrow is no longer connected to you, but it's still considered to be directly from you. Aval im yorak harok v'nafal al haaretz v'achar kach niskal mehem adam. Well, let's say you spit and a whole wad of saliva or mucus is now on the ground. And then 5 minutes later, a person walks by and he slips on your loogie, if you'll excuse the term, and he ends up getting damaged as a result. Areze chayav mishum boro. So you're going to be liable, but not because you've directly damaged him, but because you've created a bore. And bore is one of the damages that is discussed in the Gemara in Bava Kama as one of the 4 forms of damage. If I dig a pit in a public area, such that human beings or property can be damaged as a result, I'm liable for having dug the pit. Similarly, if I place a hazardous something or other in a public area, such that I put a banana peel in a public area that people can slip on, so then I'm going to be liable as well. Shekol takola told those 4 he below mishum adam. So what difference does it make whether it's called directly from a person or because of a person's bore? He says, "V'nafkamina but debazeh potter al hakelim shenishberu the shvira shalahen himisasan." He says the difference will be is that when it comes to the damage of bore, you're only liable for human beings and animals that are injured, but you're not liable for inanimate objects that get broken as a result. So the Torah explicitly excludes inanimate objects that are damaged. So if I cause damage to a person's property, inanimate property, directly by throwing a rock at it, and I shatter his vase, so then I'm liable. But if a guy's carrying a vase, he slips on my banana peel that I put in Rishus Harabim, or the mucus that I left in Rishus Harabim, and he slips and falls and the vase breaks, but he's totally fine, so then I'm not held liable, al pi halacha. In other words, I can't be sued in a base. So he just wants to make sure that we understand that there's different forms of causative damage, and the halacha will vary depending upon what kind of damage it's classified under. There's what's called nezek adam, which is directly a result from inertia that comes from my body, whether it's a projectile that I've thrown, or an arrow that I've shot, or spit that came out of my body. And then there's also the indirect damage of bore, where the halacha will change. Even though I may be held liable for certain things, I might not be held liable for other things. Okay, let's continue.
Rabbi,
Yeah.
What about in a situation where you just weren't proactive? So, for example, I think we have the responsibility to, in the wintertime, to shovel off the snow on the sidewalk adjacent to our house if we have a sidewalk. A lot of people do. So in that case, you're not damaging anybody. You just haven't been proactive in getting out there and shoveling the snow, and somebody slips and hurts himself.
Right. So halachically, you really can't sue for that. But there's something called dina de malchusa, like we've been learning all along, which is if the law of the land holds you personally liable for any slip and fall on your sidewalk, then you will be held responsible. So if the government basically requires it of all homeowners to shovel their sidewalks, so you could be held liable based on dina de malchusa, even though the halacha will not hold you liable. But you're right, doing a passive act of doing a passive act of just not shoveling snow at face value will not hold you liable, even though it's on your property. especially because it's on your property, because no one who said that. The question is, whose property is it? The sidewalk doesn't really even belong to you. It's really only that the government requires you to keep it clean. But that's a government requirement. It's not a halachic requirement.
I presume that would be different on your steps. For example, if you invite the mailman to deliver mail or a delivery person who's coming because you want them to come.
Right. So we'll see. I think we'll get into some of these halachas. If someone gets injured because you invited them onto your property, so then you might be held liable. Yes, it's a good point. Like, what if you invite someone to come to your house and the dog bites them, right? So you could potentially be held liable for that as well. Okay, let's take a look at another case in the Biurim. He writes as follows: Nistapakti im adam hichnis katan l'tochanut d'chlei zuchuchit. Izzy, what's your grandson's name?
Tzvi Chaim.
Tzvi Chaim, how old are you?
9.
You're 9. Okay, so you're a little bit too old for this illustration. But let's say we're talking about a 3-year-old, okay? A 3-year-old, what would be the halacha if I allow my 3-year-old to run into a store that sells very fragile and very expensive crystal, okay? The low shamar olav, and I don't watch over the child. And I say, okay, mommy's going to come, or daddy's going to go into the store. We just want to look around a little bit. And you don't watch little Tzvi Chaim when he was a 3-year-old to make sure that he's not going to smash up any of the crystal in the store. Shiber hakatan kelim. And through that, because of a parent's inaction, the child ends up breaking some items in the store. Does the adult now bear the responsibility for paying for the damage? V'nira l'chaora de'ein l'chayav midina. It would seem that, according to the letter of the law, we would not be able to hold an adult liable. The vadai delo adif migrama. It's no different from grama. It's a causative act because I didn't do it directly. It's not my animal. It's not child's not my property. He says, even when you do an action that will cause damage, if it's not clear direct damage, you're going to be pater. Like the Gemara says, and the Shulchan Aruch says, that if you sick your dog, or if you sick someone else's dog on your friend, then you're going to be pater midinei adam. At least you'll be exempt from a mortal court because I go ahead and I provoke someone else's dog to attack a third party. So I can be held blameless because it's not my property that causes the damage. So certainly if I just let a child run loose and I don't do anything, so then I would also be held blameless, at least from a basement. Okay. Who adin benidon zelo bori hazeka. So v'harei lo matzinu chiyav shmira al katan kemo she'ika chiyav al balei chayim. And there's no halachic obligation to watch your children in the same way that there is to watch your animals. And even with your own animals, we say that you're only liable if your animal causes damage when you place it right up in front of your friend's property, like you take your animal and bring it over to your friend's field and he starts eating the stalks. But if the animal goes on its own volition, and I had properly barricaded the animal, but it escaped and it went ahead and ate my friend's azaleas, so then I'm going to be pater midine adam at least, because I've only done a grama. So he goes through this whole issue. So only if you were to instruct the child, here kid, go ahead and knock yourself out and break some crystal, that you would be held liable, but not if the child does it himself. But he says, but I'll take it one step further. Not only are you going to be pater midine adam, but you may also be pater midine shamayim, from a heavenly standpoint, if you didn't watch your child and the child went in and broke the crystal in the store. And his reasoning will have to wait until tomorrow to see that. We'll hold it here for